Dr. Michael was found guilty of misconduct by a Medical Practitioners Tribunal in January 2020 for recording false information in medical notes about contacting other doctors and claiming to be diabetic. The MPT determined that Dr. Michael's fitness to practice was impaired by this dishonest conduct and imposed a 12-month suspension. Dr. Michael appealed the decision, but the appeal was dismissed by the High Court in April 2020, and the suspension took effect from April 22, 2020, to April 21, 2021. This hearing is conducted to determine if Dr. Michael's fitness to practice is still impaired by his historic misconduct. In March 2021, another MPT reviewed Dr. Michael's case. Dr. Michael was not present or represented, and the MPT determined that it was not in the public or Dr. Michael's own interest to proceed in his absence. The MPT extended Dr. Michael's suspension until May 21, 2021, to ensure proper notice could be served and to maintain public confidence in the medical profession. The May 2021 tribunal reviewed the case, but Dr. Michael was not present or represented. The tribunal noted that Dr. Michael had not provided evidence of insight or remediation and determined that his fitness to practice remained impaired due to his misconduct. As a result, the tribunal imposed a 9-month suspension on his registration to give him time to re-engage with the GMC, demonstrate insight, and address his misconduct. The 2022 tribunal reviewed Dr. Michael's case on 6 January 2022 and determined that his fitness to practice was impaired due to his misconduct and lack of engagement with the GMC since April 2020. The tribunal imposed a suspension of 12 months to allow Dr. Michael to re-engage with the GMC, demonstrate insight, and show how he has remediated his misconduct. The tribunal directed future reviewing tribunals to be assisted by evidence of Dr. Michael's updated knowledge and skills, a reflective statement, evidence of professional development, and details of any courses or study related to his misconduct. The evidence before the tribunal showed no change in circumstances of Dr. Michael's case. The GMC's representative submitted that Dr. Michael's fitness to practice remains impaired and the persuasive burden is on Dr. Michael to show he is fit to practice. The tribunal reminded itself that it has the final decision on impairment and must determine whether Dr. Michael's fitness to practice is impaired, taking into account his conduct and any relevant factors such as whether the issues have been addressed. The burden is on Dr. Michael to show that he is safe to return to unrestricted practice. The tribunal determined that Dr. Michael's fitness to practice is still impaired due to his misconduct and lack of evidence showing otherwise. The tribunal concluded that there has been no change in circumstances and no new evidence has been provided by Dr. Michael. Dr. Michael appears to have disengaged from the regulatory process, and the absence of new information resulted in the tribunal finding impairment in order to protect the public and maintain confidence in the medical profession. The tribunal has determined that Dr. Michael's fitness to practice is impaired by reason of misconduct and must now decide what action, if any, to take regarding his registration. They have considered the evidence and the submission made by the GMC representative, who suggested a suspension as the appropriate sanction since Dr. Michael has not shown insight, remediation, or remorse and has disengaged from the regulatory process. The Medical Practitioners Tribunal considered taking no action, but determined that a sanction was necessary to protect patients and maintain public confidence in the medical profession. The tribunal then considered imposing conditions on Dr. Michael's registration, but concluded that it would be unworkable due to his lack of engagement. The tribunal ultimately determined that a period of suspension would be the appropriate and proportionate sanction. The suspension will last for 12 months. The tribunal has directed a review of the case to be held shortly before the end of the suspension period, and the onus will be on Dr. Michael to provide evidence of his efforts to improve. Dr. Michael has a right to appeal the current decision of the MPT, and should he exercise the right of appeal, current suspension will remain in place during the appeal period. For review hearing, the tribunal suggested that Dr. Michael provide evidence of keeping his knowledge and skills up to date, a reflective statement showing his insight, evidence of continuing professional development, details of any courses or studies he has undertaken to better understand his misconduct and the tribunal's initial findings, and any other information that he thinks may assist the reviewing tribunal. The tribunal considered whether notice of the hearing was properly served on Dr. Michael in accordance with GMC Rules and Medical Act 1983. All reasonable efforts were made to serve notice, including sending emails and recorded delivery mail to Dr. Michael's registered addresses, but with no reply received. The tribunal is satisfied that notice was properly served. The tribunal then considered whether to proceed with the case in Dr. Michael's absence and determined that it is both fair and in the public interest to do so, as Dr. Michael has voluntarily waived his right to be present and there is no indication he would attend a future hearing if the case was adjourned.